Hi everyone, Dave Sugden of Evidence at Trial. If I were to ask you to identify the first thing you think of when you hear the term judicial notice, if you were to say, that's easy, Usher and Justin Bieber, you'd be right. What am I talking about? I'm talking about the case of Copeland versus Bieber.
What do you mean?
What happened in that case? It's pretty interesting. The plaintiff, Devin Copeland, aka Dorico, according to his complaint, wrote a song called Somebody to Love. He then took it to Usher, and according to Dorico, Usher loved it, wanted him to record it, and they were going to go on tour together, and the rest would be history, and Dorico would be a household name. But according to Dorico, Usher changed his mind and instead found a protege, a guy named Justin Bieber, had Mr. Bieber record the song, and the U.S. had to suffer another Canadian pop artist. And so what does any of this have to do with judicial notice? In response to the complaint, before any discovery was done, what the defendants did, Usher and Mr. Bieber, is provide the court with the songs. And they asked the court to take judicial notice of the songs. And what is judicial notice? It's really a shortcut of providing information or facts to the court without having to submit evidence. And so when is judicial notice allowed? In California, we look at sections 451 and 452. And what those sections say is, in section 451, it identifies those matters which must be judicially noticed, and section 452 identifies those matters which may be judicially noticed. With respect to mandatory judicial notice, the list of items includes the decisional, constitutional, and public statutory law of California and of the United States, administrative regulations of California and federal agencies, the rules of professional conduct and the California rules of court, and rules of pleading, practice, and procedure prescribed by the United States Supreme Court for federal courts. The list also requires courts to take judicial notice of the true significance of all English words and phrases and all legal expressions. Finally, and this is where the murkiness comes in, a court must take judicial notice of universally known and indisputable facts. That's in section 451F. And so here, because there wasn't really a dispute as to which song was which, the defendants were able to provide those songs to the court and have the court decide the case. And the trial court listened to the music and said, case dismissed, the songs aren't similar. The case goes on appeal and the Fourth Circuit reverses. And in fact, the Fourth Circuit does the same thing, taking judicial notice of the songs, and is amazingly hip in their analysis of the songs in their reversal. The Fourth Circuit Court held that, though all fall under the same broad umbrella of popular music, the Copeland song is squarely within the R&B subgenre, while the Bieber and Usher songs would be labeled dance pop, perhaps with hints of electronica. And what the court then did was send the case back to the trial court, where it subsequently settled for a confidential amount. So there you have it. That is judicial notice. And that's why when we think of judicial notice, we think of Usher and Justin Bieber. I hope this was helpful. If it was, please download, rate, review, subscribe to our YouTube channel. And if you'd like to take a deep dive, check out our courses at evidenceattrial.com. Thanks for watching.